Welcome to Hull and Estates and Succession Planning, a series of podcasts hosted by Hull and Suzana Popovic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull in Toronto, here are Ian and Suzana.
Hi, and welcome to Hull and Estate and Succession Planning. You're listening to episode 186 of our podcast on Tuesday, November 10th, 2009.
Hi, Suzana.
Hi there, Ian. How are you?
Great. Welcome back.
Thank you very much.
You were much missed. The solo podcasts aren't the same.
I appreciate you taking the bullet for us and keeping them going in my absence.
All we can do is try. All right. Well, what we like to do is just finish off our discussion about the special type of compensation, and that is compensation for attorneys and guardians of personal care. Mm-hmm. And in our last podcast, which you know only because you have seen it but not weren't participating in it, we were just sort of talking about the interesting difference between trying to get paid for that service as opposed to the traditional and conventional getting paid for as a power of attorney for property. So we're going to have a fancy slide flash up at this point, we're hoping. There's the last sort of 4 points that we wanted to raise. The first one is...
And the first one is that even though there is no statutory regulation that actually sets out what a power of attorney for personal care is entitled to for compensation, like there is for a power of attorney for property, that tariff amount that you've talked about previously on the podcast, that's not a prohibition from a power of attorney for personal care being entitled to get compensation for the work that they do.
Absolutely. Just because it's not written down doesn't mean you don't get paid.
That's right.
And that's special because the courts have really identified that in Ontario, and they're starting to embrace that globally.
That's right.
Now I say globally, maybe not internationally. But. All right, so that's number one. Just because it's not in the statute, that's not a prohibition in and of itself. No. What's the next one we're going to talk about?
The other one is that when it comes to a quantum of compensation, there really is an issue of reasonableness. Courts are going to look at what it was that you've done and whether or not your claim for that work is reasonable. And because they don't have the tariff amount or those kinds of guidelines when it comes to compensating a power of attorney for personal care, they're going to look at the big picture and the scope of the services that were actually rendered.
And we find that it's useful to go back to what the courts are most comfortable with in terms of quantifying compensation, and that is the tests that are being used for power of attorney for properties, and that is sitting down, making sure we keep lots of good records, making sure that we can identify it, and under the Ontario Substitute Decisions Act, there's actually a care record you're compelled to make and continue to make and update as a power of attorney for personal care. So in so doing, it's not a bad idea to add a column on that and talk about how much time that care took.
That's right, because that really is, when it comes to quantifying the claim for compensation, if you can point to the number of hours that you spent doing something, it's so much easier for a judge to feel that they can allocate a value to that as opposed to just the nature of the work that you were actually doing.
All right, so it's fairness and it's compensation based on tangibles that also tie into the quantification of it. All right, well, I think that was really all we wanted to talk about on the question of personal care payments at this point. We will revisit it as we talk a little bit about some of the compensation issues that will arise later on. But staying in our theme and our series on power of attorney and the kinds of things that clients can expect to have to address and consider when they might come to see a lawyer and may come to see us and in this case, let's talk a little bit about maybe a bit of a non-contentious elements, and that is what is going to be expected of us as the power of attorney. What are our duties? What are our obligations once we take on this job in either form? Either take it on as having been appointed by power of attorney under a document, a power of attorney document, or being appointed by virtue of the court order appointing you as a guardian or as a committee or however you call it in whatever jurisdiction you're working out of. Right. What are some of the obligations we're going to have and duties?
Well, the first one, Ian, and the clearest one is the duty to keep records. Even if you're a power of attorney for property, you're going to make sure that you're keeping track of everything that you do for that individual, and if it's personal care stuff, you're going to keep a log, as we just talked about, of the kinds of services that you're providing, because at the end of the day, that's how you can quantify the value of the work that you've done.
And we've said it before, and we'll say it again, every receipt matters, every piece of paper matters when you're going to use someone else's money. And it's no difference. I tell my kids when they go to McDonald's and I say, get a receipt, and they look at me funny, and it's like, you know what, you got to learn that you take $20, And where did the $20 go? Now, they tend to keep the rest of the $14 that's left, which is a struggle in its own right. But the point is that that's the kind of expectations the courts have, literally down to the wire in terms of keeping receipts.
And Ian, when we say that, we have to really underscore why that's so important, because at the end of the day, if you can't back up the entry in the accounting, that's sort of another further requirement of an attorney at the end of the day, is to actually pass accounts or prepare accounts that could be passed. If you can't substantiate a payment that's been made out of an incapable person's funds, then you're going to have to pay that money back. And that's is about as crass as you can be about it. So that's why every piece of paper, every piece of proof of the payment and the reason for the payment is really quite crucial.
It's absolutely vital, and I'm guessing I'm going to have a collection problem with my kids on their $20 that they've swiped from me. But that's so true. All right, before we continue on with this, and we're going to really flesh out some more of the duties as we move on with our podcast in this mini-series we're working on, I did want to talk a little bit about a book that we're having some fun enjoying as well, and it's called The 101 Biggest Estate Planning Mistakes. It's by Herbert Nass, N-A-S-S. Now, this is a fun book because this is, it's a U.S. book, so the experience has got some of the U.S. Bent to it, but 101 estate planning mistakes. And we just got this in, not that it's brand new, but it's published by John Wiley & Sons, Inc. We'll put it in the show notes. But it's kind of fun to see how someone else has approached the kinds of mistakes that come in an estate. So I encourage it. I know you and I are now trying to Twitter every day, once or twice a day, and last week one of my posts was just on this book and sort of reminding people. And the only point I do want to say is, last point on this little discussion of what I'm just starting the book, but I'm finding it as interesting, is the number one estate planning mistake. The single biggest mistake is not planning on the certainty of life, that being death. Mm-hmm. So I thought that was sort of a fun way to start the book. It's got Donald Trump has supported this book on the back, and I don't know how far that takes us, but at least he thinks it's a great idea. But we were always looking for resources, seeing which ones are helpful, which ones aren't helpful. Already into this by about a third of it, and finding it very helpful and an interesting read. Another avenue to consider. It's a little off topic with power of attorneys, but they talk about the necessity to be current with powers of attorney as well. So let's come to our next podcast. Let's keep working through some of these duties and expectations. What a client is going to be when they sit across the desk from us, when they come to see us. What does a client want to learn about those duties and expectations so that they can take it away at tangibles in that regard? So thanks so much. Welcome back.
Thank you, Ian. Looking forward to it.
Appreciate that.
You have been listening to Hull and Estates and Succession Planning by Ian Hull and Suzana Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull and Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.